We call 22-39014, the state of Texas versus Stephan M. Jail, present with his attorney and the state's attorneys. The jury has called two bells indicating they have reached a verdict in this case.
Whoa, right before the jury walks in, something big just came up. That pause, that's not for drama. Something legally urgent just shifted the entire tempo of this trial.
Wait outside. I'm
sorry. Something has just come up we have to take up before we bring the jury in to take this verdict. Okay, go ahead. What state say?
So, Judge, I had first amendment notice back on August 6th of 2024.
Texas Penal Code Section 12.42F. This is a law that allows prosecutors to push for enhanced punishment if the defendant has prior serious convictions. Think of it as a legal turbo motor pass that catches up fast.
Given notice of intent to enhance this punishment under 1242F of the Texas Penal Code, it is my intention, if this is a guilty verdict, to read the remainder under paragraph 2 of that notice, like we would if it was a part of the indictment, and further presents that before the commission of the primary offense, the defendant was finally convicted of the felony of assault of a public servant on February 7th, 2017, calls number 1165 in the 21st District Court of Lee County, Texas. Gives him an opportunity to enter a plea of free or not true.
I object that it's not part of the indictment, even in the indictment, Judge. It was just given notice and that, to me, that's different. It has to be put on through evidence in reference to his prior. It's not part of the indictment that was presented to the jury, or part of his record at this point.
My response to that is an indictment is just about notice.
Mm-hmm.
So if we give someone the intention that if we give them notice in this written form, it's considered proper. We do it all the time.
I understand.
Actually, it was at the time, this was at the court's behest when we tried this case first time.
What's the
Well, we never got to that.
what's the date that you're using? Because I've got
My file mark date for this notice was August 6th of 2024.
Notice how the judge emphasizes notice over what's technically in the indictment. This is courtroom chess. The rules of procedure versus the rules of fairness. Who's got the upper hand here? Comment below.
That was me amending the prior notice because I think there was a mistake in the number of district court.
Okay, this is the first amended notice of state's intent to enhance punishment.
Correct, Judge.
You've received that, discussed this with your client a year ago.
Yeah.
Okay, you're on notice,
On my notes.
and it's formally filed. I don't see where there is a formality that needs to be made where he has to plead true or untrue. I know the way we do things on the enhancements on paragraphs that enhance subsequent paragraphs to the primary charge on indictments. But the key is given fair notice and of what the state intends to prove. And at the end of the day, he can stand by the presumption of innocence, and the law states that your burden is to prove it. Even when you plead true, when a plea of true is done, supplemental evidence is made to support the plea. But
Here's a hammer drop. If convicted, this guy could face 15 to 99 years or life. This isn't just about guilt anymore. It's about how much time he might do. Stakes equal maximum.
the defense acknowledges you're on notice. You've been aware of this first amended notice of the state's intent to enhance punishment with a alleged prior felony of assault of a public servant on February 7th, 2017, and cause number 1165 in the 21st District Court of Lee County, Texas, which the state intends to present before the jury and presumably ask for enhancement of punishment if the defendant is found guilty. Punishment would can be enhanced to no less than 15, nor more than 99 years confined in prison or life in prison.
Yes, sir.
And defense acknowledges that notice of those allegations have been received, and you've discussed that with your client. Okay. Is that true, sir? All of this, you're aware that that this prior conviction can possibly be presented before the jury, which would enhance your punishment range.
Yes, sir.
And you've discussed that with your attorney.
Yes, sir.
In the event you're found guilty.
Unanimous verdict incoming. You can almost feel the courtroom hold its breath. These 12 people are about to decide the rest of this man's life.
It's not guilty, you're walking out of it.
Yes, sir.
Okay.
In theory,
In this area somewhere.
but he's got other pending charges.
Oh, that's right. We've got a couple of other indictments pending. But that would end this case if they're not guilty. All right. We've got a verdict. Let's bring the jury out and receive the verdict. Thank you. And the record shall now show that the jury is in the courtroom. Mr. Jones,
Yes,
I
sir.
believe you are the jury foreperson.
I am.
And I'm going to ask you a couple of questions. Number one, the court has received a message from the jury that the jury has reached a verdict in this case. Is that so, sir?
Yes, sir.
Is this a unanimous verdict? That is one that is agreed upon by all members of the jury?
It is.
Do any of the jurors disagree with your foreperson's representations? No disagreement.
That's the end of phase 1. Guilty, but this trial is far from over. Next up, punishment. And trust me, it gets even wilder.
It does appear to indeed be unanimous. If you would be so kind, pass the documents to the bailiff. You may be seated. I will review for proper form and publish the verdict. And the defendant shall rise. In cause number 22-39014, the state of Texas versus Stephan Rayvon Angel, we, the jury, find the defendant guilty of the offense of murder as charged in the indictment signed by the jury foreperson. The verdict is received. It is made a part of the record for all purposes. Ladies and gentlemen of the jury, at this time, I have accepted your verdict finding the defendant guilty of the offense of murder as indicted in this case. And that brings us to a close of phase 1 of this bifurcated two-part trial. We will now proceed with the punishment phase of this trial. And once again, let me repeat, you're still under the instructions that the court has given to you up to now. Let me see lawyers, please. Thank you. Hey, get us outside right now. Tommy, come on. We need some help here. Okay, we have 3 individuals here.
Yep, you heard that right. A brawl broke out in the courtroom hallway. Chairs broken. Fists flying during a murder trial verdict. Absolute chaos.
As the court would place in the record, within the last hour, the court received a verdict from the jury in the case of Stephan Angel in a murder case, and the jury found the defendant guilty of the offense of murder as alleged in the indictment. So the court accepted the verdict and then broke for the lunch hour. And as participants and the jury and spectators were leaving the courtroom, this court saw some activity at the doorway, and I could see 1 or 2 bodies, and it was obvious that physical confrontation was going on at the doorway, inside the doorway and at the doorway of this courtroom, as the court was still in session on this matter. I've reviewed a video because we got videos everywhere. And I see three people flailing, punching at each other at the doorway of this courtroom and breaking some of the chairs outside. But it was a free-for-all fist fight going on. Y'all three, I recognize all three of you. This is a court of justice, a courthouse of justice, of honor. This is the last thing that should ever happen in this building, because we're trying to resolve problems in a humane and dignified and educated and advanced method. We're not cavemen, although you three acted like